Yes, Mr. Mitri.
Please the court. I appear with Mr. West QC and with Mr. Howell for the appellants for the funds. Mr. Hoskins QC appears with Miss Abram, Mr. Heaton and Mr. Wood for the respondents, the banks. The appellants, the claimants in these proceedings, are funds who seek damages from the defendants, from the banks, in respect of losses caused by breaches of statutory duty by the banks. And those breaches of statutory duty comprise infringements of competition law, so infringements of Article 101 and of the domestic equivalent, Section 2 of the Competition Act.
Yes, thank you very much for the helpful skeleton arguments that you filed, which obviously we've carefully read. Can you first help us as to the division of time? We have, I think, a 2-day hearing, do we not?
Yes.
How are you going to divide that between you?
So we've agreed that I will take the first day, yes, and Mr. Hoskins will take tomorrow and leave me sufficient time for reply.
Sounds very sensible, thank you. My other question at this stage is about the nature of the exercise that the judge was embarked upon and that we're embarked upon.
Yes.
Are we here to decide a point of law, and was he, or is it something else?
We are here to decide a point of law. I don't think that there's any dispute about that. We say that the judge did decide.
Yeah, sorry, I didn't mean to cut you off, but if there's consensus about that, then...
I think it's quite murky, but we're happy to deal with it as if...
Right, in other words, whatever might be said about the nature of strikeout applications in relation to points of law, the parties went to have this issue decided, rightly or wrongly, and that's what the appeal is about. So we're not here talking about procedural issues, we're talking about the legal issue that underlies it, and you're both content to proceed on that basis and to argue it out.
Yes. Anything else, Stephen? No, thank you.
No, that's very helpful. Thank you. All right. I'll now get out of your path.
My lord, no, I should have given you the opportunity to ask any questions at the outset. Sorry for just launching in.
No, well, unless my lady and my lord have any other preliminaries, you can launch in.
Thank you. So the breaches of statutory duty that my clients allege comprise, as I say, infringements of competition law, both EU competition law and the domestic equivalent, in relation to manipulation by the banks of FX markets. Now, the European Commission has definitively established infringements of competition law as regards some of the relevant chat rooms participated in by the banks. And we say that the appellant funds suffered loss when they engaged in FX trading, and that's to be assumed to be correct for the purposes of this appeal. The respondents, the banks, have alleged by way of defence that the appellants passed on losses to their former investors. And pass-on is said to have taken place because, first of all, the appellant funds entered into less advantageous transactions due to the bank's manipulation of the FX market. Secondly, the effect of this was to reduce the net asset value of the funds, so what we've called the NAV. And thirdly, investors who redeemed or withdrew their investments at prices calculated by reference to the NAV receive less than they otherwise would have done at the time of redemption or withdrawal. And so, as we've just been discussing, the issue before this court is whether that allegation is sustainable as a matter of law. And I'm going to try at the outset to encapsulate the issues between the parties so that you can see where I'm heading in my submissions, and then I propose to break down the submissions and address the points that arise in more detail.
Are you going to be tracking your skeleton argument while you do that, or are you going to be...
I wasn't going to be, but I can...
Well, if at some points there are aspects of the skeleton argument that you think we should put in our notebook in order to read alongside, please tell us.
Yes, of course. There are some points, my lord, which are set out adequately in my skeleton, which I'm not going to... We continue to rely on everything in our skeleton argument.
Right. Well, give us references where that would...
My lord, the appellants contend that the bank's pass-on allegations are not sustainable in law. The appellant funds are all trusts, companies or limited partnerships. And we say that the bank's allegations are inconsistent with and precluded by fundamental principles of English law that determine how title to sue and how loss is allocated when a tort causes damage to the property of a company, a trust, or a limited partnership. And we say that in each case, title to sue rests with the company, the trustee, and the general partner, and not with the shareholders, beneficiaries, or individual partners. And so we say it follows that the banks are wrong in law to say that loss is passed on to investors. The loss is at all times loss suffered by the claimant fund, and the rights of current and former investors are determined by the rules of the funds in which they invested. The investors have no separate right to sue third parties, and that's because the law doesn't regard them as having suffered any loss, which, to use the language of Marek's, loss which is separate and independent from that suffered by the company, trust, or partnership.
Did you use the word third parties? By that, is that a convenient way of referring to shareholders, beneficiaries, and individual partners? I mean, is there some formulation that you want to give that encapsulates who you're talking about in each of these cases?
My Lord, by third parties, I mean the tortfeasor, the wrongdoer. So
the wrongdoer, okay.
Yes.
That third party.
That third party, my Lord,
Yes,
yes. Now, before this court, the banks advanced two main arguments in response to our appeal. They say, first of all, it doesn't matter whether former investors have title to sue the respondents. Because they say what matters is whether, in fact, losses have been passed on as a matter of fact.
That's not the position they adopted below.
It's not the position they adopted below. No, there's a dispute about that, my lady. We say that it's not the position they adopted below, and we don't take any point about that. So we're not saying that they're precluded. It is a point of law. We accept that. So we're not saying that they're precluded from arguing the point now. But it is necessary to have regard to the fact that they didn't argue it below, because that sheds light on the basis for the judgment below, because the judge proceeded on the basis that what was being argued was that there's a right to sue which passes to the investor. So now they say that it doesn't matter whether former investors have title to sue the respondents. What matters, they say, is whether in fact losses have been passed on, because they say if as a matter of fact losses have been passed on, they say it would be contrary to the compensatory principle to permit the claimants to recover damages in respect of such losses, because it would lead to overcompensation.
I just remember, I have a real difficulty with the phraseology and the concept of passing on a loss. I understand that from a competition perspective,
Yes.
one talks about pass on. But as the judge said, and I think the parties accept, that's thinking about something very different. And you don't pass on a loss. You may do something which means that your loss is mitigated or avoided, but you don't pass it on.
My Lord, we entirely agree with that, because a pass on in the competition context, as the court will know, and as my Lord, you'll recall from the interchange case, generally arises where you've got a supply chain with different purchasers at different levels of the supply chain. And so in interchange, what was being alleged was that that the retailers were making claims against Visa and against MasterCard. And what was being alleged was that loss had been passed on to the retailers' customers, to the indirect purchasers, which then themselves had a claim. And so where you have a supply chain like that, one can readily see that there's a fresh purchase that takes place down the supply chain. And so there is pass-on in that sense, as we traditionally understand it.
Well, quite simply, in those situations, what you're passing on is the higher price that
Yes.
you're being wrongfully charged. So you pay extra, so you pass that on to your customers, and that's what it means in that situation.
That's right.
I think I just wonder whether the use of the term pass on in the context of thinking about whether in this sphere or in any other sphere, and I think we have to keep remembering here that all of these issues are not even remotely limited to competition law.
No.
It applies to every cause of action against a company, by a company or a trust. And we are talking here about classic issues of loss and damage, and whether they are avoided or mitigated.
My Lord, yes, with respect, we entirely agree with that observation, and we say that that essentially the problem with focusing on the avoided loss argument, the problem with the avoided loss argument, the fundamental problem with it, is that it undercuts these very important rules we have which apply to companies and to trusts, because those rules say, well, the loss resides with the company, the shareholder, or resides with the trust. The shareholder and the beneficiary can't sue to recover in respect of damage to the trust property or to the company. And that's because the company can sue, or the trustee can sue. But what's being said is, well, actually, the company or the trustee can't sue for this bit of the loss because it's been avoided, because essentially it's been passed on, in inverted commas, to the investor.
Well, the consequences of this argument by the defendant seems to me to be quite enormous. Have I understood this correctly? It would mean that in any claim by a company, of which we deal with hundreds and thousands all the time, in every single claim, one might have to investigate what changes to the share capital of that company may have incurred in the interim. Because it seems to me that every single time a company says, right, I have suffered a loss by virtue of the defendant's actions, whether tortious, contractual, or whatever, the defendant would be able to say, if Mr. Hoskins is right, well, hang on a minute. 3 years ago, you had a rejigging of your share capital, as a result of which your shareholders have been bought out, redeemed, or whatever, at 10% less than they would have done otherwise, and therefore you haven't suffered that loss anymore. It means that it's going to completely rewrite the law and the way in which companies, and if they're right, banks are right, trusts have to look at claims.
My Lord, we with respect again, entirely agree. We say the consequences would be enormous, and those consequences are precisely what the English law rules in related, that, for example, the reflective loss rule is there to prevent, and so that's why we say, in a nutshell, these arguments are wrong. The consequences would be huge. Now, what the judge found below, so the judge accepted, by and large, our arguments on domestic law, but he said, well, Article 101 means that those rules have to be, as it were, set aside or applied differently, because he said Article 101 gives any person who suffered loss the right to sue. So that's how the judge dealt with it. And this is really the second argument. So they've got their avoided loss argument, and the second argument raised by the banks is that Article 101, even though this is a domestic law claim for breach of statutory duty, which, yes, relies on Article 101 as the relevant statute, they say, well, Article 101 is special because it engages EU law. And what Article 101 does, they say, is gives any person who has suffered loss a right to sue to recover damages. There can't be a bar placed by national law on the right of any person to sue. And they say that on that basis, EC law requires these important rules of domestic law to be applied differently or set aside.
That means that then is saying it's a cause of action on the part of the investors, beneficiaries.
Yes.
But it's also saying that a third thing, it seems to me, and that is not only that they have a claim, but that it extinguishes the claim of the company or trust. And at the moment, for my part, I haven't seen that issue has really been addressed. Why does it extinguish the claim?
No, I don't think it has been addressed.
But it's essential, isn't it?
It's very important, my lord, because as I say, that the basis. Let's look at company law for the moment, and the principle in Mareks. So the fundamental rationale for the reflective loss principle as set out in Mareks is that this is loss that resides with the company, so the company can sue. And I'll come on. I know that you'll be very familiar with Mareks, but I do need to come on and look at it for the purposes of my submission in a little detail. But what's clear is that one of the key rationales behind the reflective loss rule in Mareks, as affirmed by Mareks, is to avoid all of the sorts of practical difficulties that your lordship was averting to would arise if the banks are right. But the upshot of the rule is that loss resides with the company, and it is the company that sues. But the upshot of the bank's case is that there's a cause of action on the part of investors, and the company can no longer sue for the loss, but the investors sue instead. And we say that that's to turn the law upside down, and there's nothing, this is really key, there is no case, no European law authority which establishes that. So there's no judgment of the CJEU which grapples with the position where you have a legal entity such as a company or a trust or a partnership which has participants in the legal entity, and where national law has rules which allocates loss and title to sue as between the different constituent elements. So there's no CJEU judgment that says, well, in cases like that, the national rules have to be set aside because of Article 101. What they rely on indirectly is the Korean case, and I'll come on to show you why the Korean case doesn't say what they need it to say. The only case which has grappled directly with this issue is the judgment of the Irish Supreme Court in O'Neill and Ryan. That does grapple with these issues, and we say that it's right. It was correctly decided. The banks say, well, it was decided a long time ago, pre-Marex, but actually it gets the rule in Prudential completely right, and moreover, it finds that European law doesn't have the consequence, the undesirable consequence, of overturning that domestic principle.
Could I ask you something rather basic? The banks resist this argument on the footing that you'd be greatly overcompensated.
Yes.
Your argument is that they'd be getting away with what they've done. But focus for the moment on the greatly overcompensated argument. Because they weren't able to argue that you could and did actually in some way set off your losses, you get overcompensated.
Yes.
Could I put myself in the shoes of the individual trustee or the present or past shareholder or the beneficiary? And if that's the answer, how stand those individuals in terms of recouping from you? Or is the consequence of your argument that that's tough for them?
My Lord, it's a very good question with respect. The consequence of my argument is that it all depends on the internal arrangements of the company and of the trust. And so there may be arrangements in a trust where the trustee sues in relation to a wrong that has happened previously that's only just been uncovered.
Dare we say, is then obliged to pass on.
And then is obliged to pass on. So, my lady, exactly. But the arrangements may say otherwise, and it's all the fundamental premise of English trust law is that all of that is governed by the internal relations, the internal arrangements in the trust.
So, if I'd, for example, sold my share, in the meantime, that might just be life, as it were.
And that's really how companies are set up. That's right. Now, it may be that there are arrangements between the shareholders and companies which mean that compensation is again passed on in inverted commas to the ex-shareholder.
But that's part of the bargain between the individuals
part of the bargain.
And the institutions themselves. And so there is a risk, you'd be bound to accept, of people in your position being overcompensated. But that is only overcompensation in terms of the bargain that existed between them and the individual participants.
My Lord, yes. May I just make 2 points in relation to that? The first is, and I hope it doesn't come across as a semantic point because we say it does have substance, it's not overcompensation because the very...
The loss happens at the time it happens. What happens downstream or upstream doesn't affect the loss at all.
That's correct.
Which I think is what my Lord Justice Phillips was touching on at the beginning.
That's exactly right. And also because the legal entity is there to recover damages for shareholders and beneficiaries who exist for the time being. That's how the entity works. So that's the first point. The second point I make is that this so-called overcompensation point works both ways because it may work the other way around. It may be that, for example, the company or the trust that there's some latent claim against it. So actually what you have is a shareholder or beneficiary who redeems their investment and gets more than current shareholders. And then the question of whether the company or the trustee can pursue them again will be a matter for the internal arrangements of the trust.
Well, the consequences of all this, again, would be, once you get into this sort of argument, would be enormous. What if a company, for instance, suffers a big loss by virtue of somebody else's fault? So they pay their employees less. Maybe their employees are entitled to a bonus based on the company's performance. Because of the loss, the employees get less. Does that mean that the company can't then claim that loss because it's been avoided or mitigated?
Or has to give credit for it?
It's just the way the company deals with its affairs.
Yes.
When it claims for the loss, it doesn't have to give credit for the fact that it may have adjusted its affairs internally to reflect the fact that it suffered the loss.
My Lord, quite so. That is our case, and we say, moreover, that the banks, for reasons, no doubt for forensic reasons, are trying to distinguish in their arguments. Indeed, the judge below distinguished between the position of current shareholders and former shareholders. Well, now, not only has that distinction been disapproved in the Primeo case, the Privy Council, but it's an unprincipled distinction, really for the reason that my lady just gave, which is the loss is suffered at the outset when it's suffered. And so take the position of a current shareholder. So a company's caused loss. The company, therefore, pays a lower dividend that year, or maybe no dividend, when it otherwise would have paid a dividend had it been more profitable, but for the infringement of competition law. That current shareholder has suffered a loss which might be said to have crystallised in the form of a lower payment, a lower dividend payment. Now, the banks say, well, you don't have to worry about that. That's a question for another day. The court doesn't need to trouble itself with that point. But with respect, it does, because there's no difference between a shareholder who redeems their shareholding and the loss is crystallised in a sum of money in that way, and a shareholder who maintains their shareholding but receives a lower dividend because of the damage to the company. There's just no analytical or principled difference between those two things. And so that's another problem which we state up front in terms of the bank's argument. So, my lords, my lady, I think we've canvassed in the introduction much of the ground that we're going to traverse. These really are, the points are actually quite narrow, but they are extremely fundamental for the reasons that we've been canvassing. And they really go to the heart of how domestic law treats all sorts of claims in tort against companies and trusts and limited partnerships. And what I was going to do in order to make my submissions in more detail was, first of all, take the court to the respondents, to the relevant pleadings. I can do that very briefly.
Do you want to give us just a map of where we're going to be going during the course of the day? What are the main topics?
Yes, so I'm going to take the court to the pleadings, then I'm going to take the court to the key authorities which establish that English law establishes that title to sue is allocated in each case to the company, the trustee and the general partner, and that investors are treated as having suffered no separate and independent loss to the funds. And those authorities include, as I say, the Primeo judgment of the Privy Council. Then I'm going to address the first of the respondents' arguments on avoided loss. Then I'm going to address the second argument based on Article 101. And I'm going
the first, you say avoided loss, is that the investor's title point?
The avoided loss is the point that the banks now make, which they didn't run below, which is that it doesn't matter if the investors don't have title to sue for the so-called loss that's been passed on.
I was just getting away from avoided loss because it may be a contentious.
Well, I'm calling it that, my lord, because that's what the banks call it. But really, right. Their argument, if we can call it the compensatory principle, if you like, because what they're saying is that because loss as a matter of fact is avoided by the redemptions or withdrawals.
Well, I'll call it in my own note compensation. So that's that topic. The next one is.
The next one is Article 101.
Yeah.
And that's really it. During the course of these submissions, I will, of course, take you to the judgment below to show you how the judge dealt with these various points. So, can I just show you the key features of the claim? So nothing really turns on this, but I think we can take it from the introduction. So if we're in Core Bundle 1, can I just check whether you're working from electronic or hard copies? I think we're all working from hard copies, but I think the pagination is exactly the same, but please tell me if it's not. So we're in Core Bundle 1.
It never is.
Well, I hope someone behind me will help me.
The person who's capable of creating an electronic bundle that has the same pagination has not yet been born.
They'll be awarded the Nobel Prize when they come up with the trick.
It will by me,
It will
yes.
help all of us.
All right, we've got the core bundle.
So do you have tab? So tab 14, Core Bundle 1, tab 14,
Yes.
page 181. And you can see that this. I'm really only going to take you to the introduction. It's a very lengthy pleading, and I'm just going to show you the core elements of the claim in the introductory section because we don't need any more than that for the purposes of this hearing.
Yes.
So you'll see the claims period is set out. It's some 10 years. That's set out in the first paragraph. And if you go over the page, please, to 182, you can see that the claimants are primarily investment management firms, and they include the well-known firms there listed. Just to be clear, not all of the claimants are appellants. Most of them are, but there are some claimants which are not structured as trust companies or limited partnerships, but most are. So there are some claimants who are, in respect of which, for example, these pass-on arguments aren't made, and they're not appellants in this appeal. Then, if you turn, please, to page 184, paragraphs 8 to 9, you can see the allegation that the defendants were involved in anti-competitive conduct in the FX market, including the exchange of commercially sensitive information and the pursuit of altered trading strategies based on the information so exchanged. And then you can see at paragraph 9 that there have been, then at that stage, 2 commission decisions, now 3 commission decisions, since the pleading was amended, which establish the infringement in respect of some of the chat rooms. Now, so this claim proceeds partly as a follow-on and partly as a standalone claim.
But you want to go further than these decisions do?
That's correct, because there are, my lady, that we say that the commission, there are hundreds of chat rooms, and we say that the commission exercised its prosecutorial discretion in focusing on some to establish in principle the infringement. But we want to go further.
And are the further allegations all denied?
They are denied. They are denied in terms of loss having been caused.
Not in terms of breach.
Well,
don't worry, it doesn't matter for today's purposes.
They are denied in terms of breach.
Okay.
I think they are denied in terms of breach.
Yeah, there's certainly no admissions for the
There's no
standalone
admissions.
claims as the pleadings.
Thank you.
I think that's a more accurate way. There's a variety between the defendants of non-admissions and denials in respect to breach. So that's the position that we're in. Then, if you could turn to page 209, please. At paragraph 64 through to 67, I'm not going to read them out, but you'll see the types of manipulation which are alleged, and they include benchmark manipulation, bid-ask manipulation, and other types of manipulation, including collusive information exchanges. And then, again, if you would look, please, to page 215, paragraph 84, by reason of, this relates to, so by reason of the manipulation of the relevant benchmark or fixed rates, so that such rate was higher or lower than it would otherwise have been on the relevant date, the claimants entered into FX transactions over the claims period which were less advantageous than they would have been absent FX manipulation. And so this 84 and 85 relate to benchmark manipulation, but they show broadly the mechanism by which loss is caused. And then if you look over the page at page 217, 2 pages on, or bottom of page 216, the loss resulting from collusive trading, so this is another type of manipulation, is the extent to which other market participants were worse off by reason of the trading strategies ultimately pursued by members of chat rooms, of which one or more of the defendants were parties, than they would have been if the traders had instead pursued their own independent trading strategies. The mechanism of loss therefore depends on the particular trading strategies pursued. And so you see the gist of the claim there. So what's being said is that there were these chat rooms that during the course of which the defendant banks engaged in anti-competitive conduct, such that when they traded with other parties, and in this case with the claimant funds, with the appellant funds, they were better off and the funds were worse off in those trades. So that's really the gist of the claims. And just to show you in the same bundle at tab 1, page 6, so before turning to the bank's joint further particulars of avoided loss, mitigation and pass-on, if we look at page 6 of this bundle, we can see that the order sort relates to, so at the top in section 9, vary the order and set out that the order that you're asking for. The strikeout application is granted. This is the order that's...
I'm really sorry, you've lost me on page reference. So
I'm so sorry. So it's tab 1, page 6, and this is in our notice of appeal.
Yes.
And the reason I'm just showing you this is to show you that the paragraphs of the bank's pleading, which I'm about to go to, which are relevant in this case, are paragraphs 14 to 24 and also paragraph 27. So 32 to 35 were struck out by the judge, and there's no appeal on those by the banks, no cross appeal. And so, if you could pick up, please, the second core bundle behind tab 21, page 788. This is the pleading of the defendants, which, as you can see, is headed further particulars of avoided loss, mitigation and pass-on. And if you look at paragraphs at page 789, paragraphs 2 to 3, you see that these further particulars assume that the claimants may have suffered loss as a result of the matters alleged in the present claims, but they're served without any admission as to liability. And then 3, any liability of the defendants to any of the claimants will be extinguished and or reduced to the extent that any of the claimants avoided or mitigated any such losses, including without limitation by receiving benefits arising out of the defendant's conduct as a result of losses and or passing on any such losses in whole or in part to other parties. And then really the key paragraphs, we don't have to go to all of the paragraphs that are under appeal because we can see from paragraphs 14 to 16 on page 794, and again this is common ground that the gist of the point is set out in these paragraphs. So the other paragraphs repeat the same point, but in relation, for example, to master funds. So you see at 794, paragraph 14, the defendants understand that many of the investment funds made provision for their investors' investments to be redeemed or withdrawn in specified circumstances. Then at 15, the investments of investors in any such fund may have been redeemed or withdrawn during the life of the investment fund at or by reference to the prevailing net asset value, NAV, of the investment fund at or around the time of redemption or withdrawal. If the effect of any less advantageous FX transaction was to lower the NAV of the investment fund and an investor's investment was redeemed or withdrawn in whole or in part at a price affected by the less advantageous FX transaction, that fund will have avoided all or part of its loss, or alternatively passed on all or part of its loss to the investor. Further, or alternatively, any investment fund does not have standing to sue in respect of any loss which was avoided by being transferred or alternatively passed on from the investment fund to a former investor, which comes back to my Lord Justice Phillips' point about the other side of the coin of their argument, is that it removes entitlement to sue or title to sue from the company or the trustee or the general partner.
Is the nub of this contained in the last 3 lines of 15 and and paragraph 16.
It is.
So it's those two statements that this is all about.
My lord, that's exactly right. So, my lord, we can put this away because you can see the point. And I'm going to start, if I may, with the company issue. So the position of funds which are structured as companies, with the investors being shareholders in those companies. And, my lords, my lady, the appellant submissions can be broken down into three propositions. So can I state, please, the propositions and then take you to the authorities? It's really two authorities I'm going to take you to. So the first proposition is that where an injury is done to a company and the company has a cause of action, the only person who can seek relief is the company itself, and that's the rule in Foss and Harbottle. The second proposition is that where a shareholder suffers a diminution in the value of their shares in a company, English law does not regard that loss as being separate or distinct from the loss suffered by the company. And that's the rule in Prudential as affirmed by the Supreme Court in Marex. And thirdly, that position does not change where a shareholder redeems or withdraws redeems its shares or withdraws its investment. The shareholder does not, as my lady put it, suffer any separate loss at that stage. The loss has already been suffered. And the loss was suffered when the value of the shares decreased upon the wrong being committed. And withdrawing the investment, redeeming the shares, does not create any new loss. That's really the key point. And it is the point established by the recent decision of the Privy Council in Primeo. So what I propose to do now is take the court to the relevant passages in the judgment below to show you how the judge addressed these issues before going to the key authorities. And you'll find the judgment below in Core Bond Bundle Volume 1 behind tab 10. And if we could pick it up, please, at page 117. So you can see at the top of the page the heading, the company issue. And then at 31 to 34, the arguments of the parties on this point were summarised by the judge. And so you can see, just at a glance, I'm not going to read them out, but at paragraph 31, that's our argument based on Prudential and Marex. And then you can see at 32 that it was submitted on behalf of the defendants that the rule in Prudential and Marex didn't apply, because the shareholder, when he redeemed his investment, ceased to be a shareholder and sustained a loss which was separate and distinct from the loss sustained by the company. And then you can see at 34, over the page on page 118, that what was the case that was relied on below was that the judgment in Nectarus and UCP. So there was a first instance judgment, and then there's a reasoned judgment of Lord Justice Flo refusing permission to appeal. And that was relied on by the banks in support of the proposition that the principle in Marex, in the rule in Prudential, gives way or doesn't apply when a shareholder, to former shareholders. And so they relied on Nectarus and UCP. And the key point is that that has now been disapproved by the Privy Council in Primeo, which has reached the opposite conclusion. And then if we go, so that's the argument, and if you could turn please to page 131. You can see the relevant parts of the judge's reasoning, starting at paragraph 89. To be within the rule in Prudential, the reduction in the distribution received by the shareholder must reflect the loss suffered by the company. Otherwise, it would be a separate and distinct loss. And then he says that I accept that once the sum is paid to the shareholder, the company has transferred its loss, but it's nevertheless arguable that the loss suffered by the shareholder reflects the company's loss. And that was our argument. And then counsel for the defendants submitted that upon redemption or withdrawal, the investor will have crystallised his own loss. I agree, but it's arguable that the loss is nevertheless a reflection of the same loss suffered by the company. And then, however, having regard to the restatement of the rule in Prudential by Lord Reid in Marriott, it's necessary to ask whether once the company's loss has been transferred to the shareholder and the shareholder's loss has been crystallised by that process, the shareholder's loss is separate and distinct from the company. It must be arguable that it is because the company now has no loss. And we say, well, that's rather question begging because we say that the company does have loss because the loss was caused to the company. It must be able to sue for the loss.
That's 3 times he said that something's arguable.
Yes.
Are we in the language of strikeout?
No, he's going to reach a conclusion.
I know he's going to reach a conclusion,
He is.
but I mean, no one doesn't normally say, well, that's what Ms. So-and-so said, that's what Mr. So-and-so says. You don't normally go through an intermediate stage of deciding whether it's arguable. You just
My Lord,
decide it.
You're quite right, and there is some fuzziness about all
Right, so
this.
I don't want to, as it were, get off the track that you're on at the moment, but I mean, it looks as if that might be an area of, as you describe it, of it being influenced by the fact that this was an interlocutory strikeout application.
Well, my Lord, we say it is really common ground that the court should grapple
I agree.
with the points.
Not going back on that.
No.
I just want, it was an interesting term to be using in the context of this argument of law.
My Lord, I accept that. We say that, as I'll come to show you, that the judge did reach conclusions on the point. And if we look at paragraph 94...
Just looking at the arguability,
Yes.
sometimes it's helpful to look in terms of limitation when we search for damage. If you look at the companies, when time would run for any cause of action by the company, undoubtedly, it's date of the loss, the wrong, and equally for the shareholder, I would have thought this was an obvious case where crystallisation of the loss would not be the time when under section 2 or 5 of the Limitation Act time would start to run. It would start to run at the date again of the loss diminution in value of the shareholding at the time, at the same time as the company.
My lady, yes, we entirely agree with respect with that, because, and it is
And that just goes back to AXA and Sefton and all the rest of it.
My lady, yes, so it does, this is a question that arises in the context of limitation. I'll show you an authority on that. But we entirely agree that there is an analogy, because the loss is the same loss, and one couldn't say for limitation purposes, oh, well, the loss has suddenly regained or sprung up, and so limitation that the time period begins
Put me out
to
of
run
my
down.
misery, which is the authority.
The authority is Elliot.
Oh, right, fine.
Which,
That's fine.
yes.
Thank you.
Now, I'm just looking at on page 132 at paragraph 94, and so you can see there that the way that it was argued below was in reliance on Nectris and UCP. And then there's a discussion of Nectris and UCP, and you see in the middle of paragraph 95, at paragraph 43, he said, he being Lord Justice Flo, that the applicability of the rule against reflective loss should be assessed when the claim is made at a time when the loss claimed has crystallised, not at some earlier time when, although there may have been a breach of contract, the loss claim had yet to crystallise. So you can see why that was helpful to the bank. So they say this is all a piece with their argument that some new loss is suffered upon withdrawal or redemption, and so they did rely on the observations of Lord Justice Flo in the Nectris case. And then we attempted, one of the ironies in all of this is that you see at paragraph 97 that we attempted to distinguish UCP and Nectris, because of course we did also argue, and you can see this from the end of paragraph 97 on page 133, that Lord Justice Flo was wrong. So we see there, counsel for the claimants was bold enough to say that Lord Justice Flo was wrong. I don't think it would be appropriate for me as a first instance judge to enter into that debate. And so recognising, so we did front up to UCP and Nectris, we said that this is wrongly decided, but we did also seek to distinguish it, and one of the ironies in this case is that the basis on which we sought to distinguish it is now alighted on by the banks, who say, well, that's a reason for distinguishing it, and a reason why we're the present case is different. Now, at paragraph 99, the judge says on page 133, and this really comes back to the point my Lord Justice Jackson made. He says, in deciding which argument to prefer, so he is at this stage now grappling with the issue, I think I must have regard to the justification for the rule in prudential. And he says, well, the justification for the rule in prudential is all about avoiding concurrent claims. And so he then says at paragraph 100, the context of the present case is one in which the company has, it is assumed, passed on its loss to the shareholder who has redeemed or withdrawn his investment. The context is therefore not one in which the company would be expected to be dealing with a claim for compensation in respect of that particular loss. Although the company, of course, retains the right of action to sue in respect of damage caused to the remaining property of the company and for the benefit of existing shareholders. In such context, the stated justification for the rule in prudential has little, if any, traction. There's no risk of, essentially, of current claims and double recovery. So that's the reasoning of the judge. So he says that prudential is all about avoiding concurrent claims. Here there is no concurrent claim because the claim will pass to the former shareholder and the company won't be able to exercise it. We say, of course, this completely turns the reflective loss principle on its head. And he therefore reaches his conclusion at paragraph 101. The rule in prudential does not bar claims by former shareholders against third parties, i.e. tortfeasors, for damages in respect of the losses transferred or passed on to them by the company. So that's the judge's reasoning. And we say with respect that the judge's reasoning here is circular because he assumes the point in issue whether the loss has been passed on to shareholders when they redeem or withdraw their investments, which was, of course, the very point in issue between the parties. So he says, well, it has been passed on, therefore there's no problem with Marex, therefore the reflective loss rule doesn't apply. And we say that that's circular reasoning. And we say also, we submit with respect, that the judge's reasoning entails making an exception to the rule in prudential that applies where a shareholder redeems their shares. And so the judge accepted the bank's argument that redemption of shares crystallises or gives rise to a separate and distinct loss to the shareholders, distinct from that to the company. And we say that this reasoning can no longer stand following Primeo. And I'm going to take the court next to Marex and then to Primeo. So that's how the judge addressed the point. Marex you will find in Authorities Bundle 5 behind tab 43. Starting at page 1271, and can I please take you to page 1288, which is towards the start of the judgment of Lord Reed, with whom Lady Black and Lord Lloyd Jones agreed. There's then a separate judgment from Lord Hodge in the majority, and there were three dissenters. And if we could look, please, at paragraphs 9 to 10 on page 2188. So, so what's being said there is that I'm looking just 1/3 of the way down, paragraph 9, the reference to the highly specific exception to the general rule, and that's the exception in prudential, that a shareholder cannot bring a claim in respect of a diminution in the value of his shareholding or a reduction in the distributions which he receives by virtue of his shareholding, which is merely the result of a loss suffered by the company in consequence of a wrong done to it by the defendant, even if the defendant's conduct also involved the commission of a wrong against the shareholder, and even if no proceedings have been brought by the company. As appears from that summary, the decision in prudential established a rule of company law applying specifically to companies and their shareholders in the particular circumstances described and having no wider ambit. And then we see at 10, the rule in prudential is distinct from the general principle of the law of damages that double recovery should be avoided. So just thinking back to what the judge saw the rationale as being, this is here that Lord Reed is saying, well, it's not all about concurrent claims and double recovery. In particular, one consequence of the rule is that where it applies, the shareholder's claim against the wrongdoer is excluded, even if the company does not pursue its own right of action, and there's accordingly no risk of double recovery. That aspect of the rule is understandable on the basis of the reasoning in Prudential, since its rationale is that where it applies, the shareholder does not suffer a loss which is recognised in law as having an existence distinct from the company's loss.
So you say that's the rationale.
And we say that that is the rationale.
Could you just, in a nutshell, and I mean in a nutshell, when you're going to these cases, just situate it within the facts of those particular cases? So starting with this one, I mean, this was a asset stripping case, but could you just...
Yes, the oddity about this one is it wasn't actually... So this was a case all about creditors, and so it's not actually particularly illuminating to look at the facts of this case, because it was a case about creditors rather than shareholders. But in the course of... So what was being argued was that the rule in Prudential was of wider significance, so it applied to not only to shareholders, but also to creditors and other third parties whose loss might somehow be said to be connected with the loss suffered by the company. And what was being said was, no, it's not wider than that, so it's a rule confined to shareholders. But in the course of that, the reason this judgment is important on reflective loss and the position of shareholders is that the Supreme Court, which was sitting in a larger formation, took the opportunity to review the rule in Prudential. So, my Lord, generally I will take you to the facts, but in this case it's not particularly
This was to do with the order of precedence of creditors.
Yes.
In the end, that was what the battle was about.
That's what the battle was about. But plainly, what was being argued was that the rule in Prudential should be revisited, and so that's why there is a very full exposition of the rule in Prudential and the rationale for the rule. Of course, Prudential itself was a judgment of this court. So, my Lord, you then have, if we can go to page 1291, at paragraph 24, you have a discussion of Prudential, of the case itself, and the issue in that case was whether the shareholders could pursue their own personal claim of fraudulent misrepresentation. So there was they had their own, there was in principle a claim open to them of fraudulent misrepresentation, in that misrepresentation had been made to them as well as to the company. And that's, we say, directly analogous to what's being said in the present case by the banks, which is, well, the shareholder investors have their own claim under Article 101. But the point about the rule in Prudential is that even where there is a separate cause of action on the part of shareholders, it cannot be ventilated, it can't be exercised if the loss is reflective of that suffered by the company. And so that's the very thing that the rule in Prudential precludes. It's not enough to say, well, there's this cause of action under Article 101. We don't anyway accept that there is a cause of action conferred on investors. But that wouldn't get them very far on the company law point.
Well, if they didn't have a cause of action, you wouldn't need the rule against reflective loss.
No, that's correct. But what they say in relation to... So that's correct. But what's being said in relation to the company law point is that... so the rule in Prudential says, well, if there is... It takes the rule in Foss and Harbottle one step further, as it were. So it says, well, if there is a cause of action on the part of the investor, it can't be exercised. And what's being said by the respondents in relation to trusts, for example, where the rules are slightly different but analogous, they say, well, English law permits separate causes of action, where there is a separate cause of action by a beneficiary. And we've got this one under Article 101. And so what I'm saying in the context of company law is that here, the Prudential rule says, well, even if there is a separate cause of action, it can't be exercised. And so it's slightly different in company law than it is in trust. So that's the limited point I'm making for these purposes. And then 26 to 28, we see that what's being said here is that loss, in fact, to the shareholder is simply not loss recognised by the law, and we can see that in the citation. So from Prudential at paragraph 27, the shareholder doesn't suffer any personal loss. This is on page 1292. His only loss is through the company in the diminution in the value of the net assets of the company. The plaintiff shares merely a right of participation in the company on the terms of the Articles of Association. The shares themselves, his right of participation, are not directly affected by the wrongdoing. The plaintiff still holds all the shares as his own absolutely unencumbered property. And then at 28, that reasoning requires elaboration. It's unrealistic to assert as a matter of fact that the shareholder doesn't suffer any personal loss. Ex hypothesi there's been a fall in the value of his shares. It's not immediately obvious what it means to say this is his only, that his only loss is through the company. It's, however, possible to explain the court's decision, particularly in the light of later passages in the judgment. As I understand its reasoning, what the court meant, put shortly, was that where a company suffers actionable loss and that loss results in a fall in the value of its shares or in its distributions, the fall in share value or in distributions is not a loss which the law recognises as being separate and distinct from the loss sustained by the company. It's for that reason it doesn't give rise to an independent claim to damages on the part of the shareholders. So there Lord Reid is saying, yes, it might be said as a matter of fact that the shares have reduced in value or the distribution is lower, and so it's unrealistic to say well, that's not loss in some sort of factual sense, but it's just not loss which is recognised by the law. That's really the key point. And then at
paragraph 32 is interesting.
32 is interesting.
Sorry, because it does raise this. There's not necessarily even an equivalence between the company's loss and the shareholders' diminution in value claim. Or loss, if you see what I mean.
Yes, quite so. That's exactly right.
You could have all sorts of complicated assessments as to the quantum of the company's loss. It's not necessarily completely passed on by any stretch of the imagination.
No, exactly. That's a very important point too, and it's also indicative of the kind of very complicated analysis that the courts would have to embark on if this rule didn't exist. But 32 is also interesting because, of course, what's being said here is that the reflective loss rule covers both diminution in value of shareholding and distributions. And it's interesting here that Lord Reid sees distribution as being something broad, because you can see here that what he says is that he envisages that a distribution might comprise, if the company's wound up, the surplus available for distribution among the shareholders. Well, of course, at that point, the shareholders become ex-shareholders once the company is wound up. But he still says that that's covered by the rule. And one of the points that we argued about below, on which our argument in this respect was accepted by the judge, was that distributions include the distribution made when the shares are redeemed. And we say that this was before Primeo. We say that the judge was right to find that, because there's no difference in principle, as I said at the outset, between a dividend and the payment of money in exchange for the shares. It's really the same thing, analytically. And we see here Lord Reid recognising in terms that a distribution is not confined to a dividend as the banks say it is. So the banks, in their respondent's notice, say that the judge got this part of his judgment wrong, and that a distribution in Marex is limited to a dividend. Now, we've dealt with this in our skeleton argument. I'm not going to repeat those submissions because, although we still rely on the point, in a sense it's all been overtaken by Primeo, which gives us, which means that we're within the first bit of the rule in Prudential as well, the diminution in value of shareholding. So, in a sense, that particular debate, we say the judge has got it right and on the face of this judgment. But it's not really necessary to elaborate the argument orally because, in a sense, it's been overtaken by events.
Another reason why the shareholders' loss, the doesn't necessarily correlate with the company's loss. I'm not sure if it's specifically referred to here. Of course, the shareholder value of the shares or the investment has to factor in the value of the company's claim.
Yes, so my lord, you're thinking about an ex-shareholder or a current.
And when you
current
start
even.
valuing,
But say a company's got a claim for £1 million.
Yes.
Well, the shareholders have suffered a loss in the value of their shareholding.
Yes.
But when you value it, you'd have to look at the fact that the company has a claim for £1 million.
Yes,
So
that's right.
The company can definitely say we've lost £1 million. Well, so the company's assets though will not necessarily have been diminished by £1 million because they've got a claim.
Yes, that's
So there isn't a you can't say the shareholder has suffered the same has suffered that amount of loss, and that's why it's reflective.
yes, and that would depend if the company's aware of the claim, I suppose.
and the notes in the accounts may say that the advice is it's a good claim or a strong claim.
But my lord, yes, I agree with the point in principle.
Can you initiate me into, I know where it comes from, but why everyone talks about reflective loss, or it seems sometimes reflexive loss, and things like this. I mean, there are other more commonplace adjectives that one might apply, aren't there?
I can't really illuminate, my lord. I think
it's become a term of art.
Mr. Howell might be able to illuminate you indirectly. Yes, I mean it is what the court is what the Court of Appeal says in Prudential, but I think you were asking for a.
Yes, I did. I mean, some of these expressions are sort of they immediately illuminate what one's talking about. I don't find it a particularly illuminating term as a
Well, at the risk of
non-specialist in
stating
this area.
the risk of sounding trite, I think the phrase was alighted on because what's being said is that the loss of the shareholder is simply reflective of the loss suffered. So insofar as the shareholder might be said to suffer a loss, in fact, as Lord Reid put it, that's simply reflective of the loss suffered by the company, because it's so that's, I think that's why the adjective was selected.
All right. Well, I'll ponder further on it. Thank you.
So returning, please, to the judgment of Lord Reid, and just going through it. There's then a discussion at paragraphs 33 to 34, so on page 1293 to 1294. What's being discussed here is what happens where a company does not pursue a claim itself. And Lord Reid points out that a shareholder may have other ways of protecting its position, including by bringing a derivative action. But then if we look at paragraph 34, the final sentence, importantly, where no such other remedy is possible, the shareholder still can't pursue their own action. So even if the company doesn't pursue an action for the loss, and even if there's no remedy such as a derivative action available to the shareholders, as of course there wouldn't be if the shareholder's no longer a shareholder, that doesn't matter. And then we see at 35 that this rule is reflects, hesitate to use the word, reflects the fact that the management of a company's affairs is entrusted to the decision-making organs established by the Articles of Association. And then we have, and this we've canvassed this to some extent already, or to a large extent already, in the discussion we've been having. But if you look, please, at page 1295, paragraph 38, Lord Reid is there explaining the practical difficulties that would arise if shareholders had their own claim. And so you see, even without the complications, I'm looking just beside letter G.
Paragraph?
Paragraph 38, my lord, at the bottom of page 1295. Even without the complications arising from the existence of concurrent claims, which of course is what the judge was focusing on as being the rationale for the rule in Prudential, it would not be straightforward to establish the extent, if any, to which a fall in the value of a company's shares was attributable to a loss that it had suffered as a consequence of the defendant's wrongdoing. But the existence of a concurrent claim would add another dimension to the difficulties. It would be necessary to take account of the fact that the wrongdoing had resulted, my lord, this is your point, I think, had resulted in the company's acquiring an asset, namely its right of action against the defendant, which might have offset any detrimental effect of the wrongdoing on the value of his shares. It would also be necessary to consider the question of double recovery and how it should be addressed both procedurally and substantively. Those issues might have to be addressed in the context of a proliferation of claims, possibly in different proceedings at different times and in different jurisdictions. They'd also arise in a context where there may well be conflicts of interest between the shareholder and the directors, its liquidator, other shareholders and creditors. So in summary, therefore, Prudential decided that a diminution in the value of a shareholding or in distributions to shareholders, which is merely the result of a loss suffered by the company in consequence of a wrong done to it by the defendant, is not in the eyes of the law damage, which is separate and distinct from the damage suffered by the company and is therefore not recoverable. Where there's no recoverable loss, it follows that the shareholder cannot bring a claim, whether or not the company's cause of action is pursued. The decision had no application to losses suffered by a shareholder which were distinct from the company's loss. And so, my Lord, just going back to the point just put to me by Lord Justice Jackson and the word reflective, here Lord Reid has happily summarised the principle without using the word reflective at all. And it may be that that's a formulation that the court...
Resulting.
Resulting. Now, Lord Reid then goes on to consider the judgment of the House of Lords, the decision of the House of Lords in Johnson and Gore Wood, and sets out various parts of the speech of Lord Bingham in that case. And we rely on the fact that the House of Lords in that case held that a claim by a shareholder for the loss of a dividend was a claim that was reflective of the company's loss and so fell within the rule in Prudential. If we go forward in Marex to page 1299, here, and this is relevant to the reasoning of the judge in the judgment below, there's the rejection by Lord Reid of the principle that the basis for the rule in Prudential is the avoidance of double recovery. And so he says you can see at 52, one problem with reasoning based on the avoidance of double recovery is that the principle is one of the law of damages. It doesn't deny the existence of the shareholder's loss, as the rule in Prudential does, where the loss falls within its ambit, but on the contrary is premised on the recognition of that loss. Applying an approach based on the avoidance of double recovery, it's therefore possible for a shareholder to bring a personal action based on a loss which would fall within the ambit of the decision in Prudential, and to obtain a remedy which that decision would have barred to him, provided the relief he seeks is not an award of damages in his favour. This device has been exploited in a number of cases subsequent to Johnson in ways which circumvent the rule in Foss and Harbottle, a rule which is not confined to action for damages but also applies to other remedies. And then moving forward to page 1301, to paragraph 61 at the bottom of the page. Here again, Lord Reid is acknowledging that distributions can take forms other than the payment of dividends, so contrary to the submissions made by the banks. So you have a citation from Lord Millett, and then over the page, at the top of page 1302, it appears from the passage cited in paragraph 62 below that those observations may have been intended to apply only to payments receivable by shareholders in that capacity, in which case they correctly recognise that distributions can take other forms beside the payment of dividends. So we rely on that on the distributions point. And then you see if you go to page 1304, there's this judgment, as the court, I'm sure, is aware, overturned the Court of Appeals judgment in Giles and Rind, and we see a discussion of that at paragraph 68 to 70. So what's being said is that the principle, the rule in Prudential, applies even where the company is disabled from bringing a claim for compensation. So the exception to that effect in Giles and Rind was disapproved. And what's being said is that the rule doesn't depend on the loss of value caused to the shareholders being made good by a claim brought by the company, because it applies even where the company can't bring a claim. And then finally, if we could move on to page 1307, please. You see at paragraph 79, just under the heading, a third of the way down, the judge drawing a distinction, which is a distinction we'll see picked up by the Privy Council in the Primeo case. So, summarising the discussion to this point, it's necessary to distinguish between, first, cases where claims are brought by a shareholder in respect of loss which he has suffered in that capacity in the form of a diminution in share value or in distributions, which is the consequence of loss sustained by the company, in respect of which the company has a cause of action against the same wrongdoer. And we say we're firmly in the present case within that category. And secondly, cases where claims are brought, whether by a shareholder or by anyone else, in respect of loss which doesn't fall within that description, but where the company has a right of action in respect of substantially the same loss. And in respect of the first kind, the shareholder can't bring proceedings. And then we see at paragraph 83 over the page, the critical point is that the shareholder has not suffered a loss which is regarded by the law as being separate and distinct from the company's loss, and therefore has no claim to recover it. And then, as a shareholder, he does have a variety of other ways which may be relevant. But again, we say that even if those ways are not available to the shareholder, the rule still applies, and we've seen that earlier in the judgment. Now, here, of course, in the present case, the loss, and looking at the formulation laid down by Lord Reid, the loss incurred by investors in the funds when they redeemed their shares is one and the same loss as the loss suffered by the company, because it comprises a reduction in the value of the shareholding as a consequence of the loss suffered by the company when it engaged in FX trading with the banks. And so that's why we say we're firmly within the first of the two categories set out by Lord Reid. So just as a lower dividend paid to a shareholder is a reflection of that loss, so too is a lower sum paid to the investor when it redeems its shares. It's one and the same loss, and there's no principled or logical distinction that can be drawn between those two situations. So I'm going to take the court now to the Primeo judgment of the Privy Council. That's in the same bundle, please, behind tab 49, starting at page 1482. And there isn't any suggestion from the banks that the court should decline to follow the Privy Council. And just in terms of situating the principles in the facts, the case concerned claims by an investment fund against its professional service providers in connection with investments the fund had made in the Ponzi scheme operated by Bernard Madoff, who, as we know, died earlier this year. And initially, the investments took the form of a contractual right for delivery up of equivalent funds to those in the investor's managed account with the scheme. And then what happened later was that the fund's investments were then converted into a shareholding in two companies, which acted as feeder funds, with those companies holding direct contractual investments in the Ponzi scheme. And the issue for the Privy Council was whether the losses suffered by the claimant fund when it made the direct investments in the Ponzi scheme, i.e. before it became a shareholder in the feeder funds, were recoverable consistently with the reflective loss rule. And the respondents in Primeo, as the banks did below, sought to rely on the decision in UCP and Nectris, in which it was held that whether the reflective loss principle applies should be determined at the time the claim is made, and that the rule therefore has no application to former shareholders. Though in Primeo, of course, the point was the other way round, because the claimant wasn't a shareholder when it suffered its loss, but became a shareholder by the time that the loss was made. So the point was the other way round. But the Privy Council directly grappled with the issue in this case and the timing point. And we can see that at page 1496. So at 45.1, the first of the issues which arise in this hearing, what is the relevant time to determine whether the reflective loss rule applies? Is it the time when the relevant claimant here, Primeo, issued proceedings, by which time it was a shareholder in Herald, that's one of the feeder funds, which had its own similar claims against R2, and Primeo's loss could be said to reflect Herald's loss in the limited sense referred to above? Or is it the time when Primeo acquired its causes of action against R1 and R2, when it acted on its own behalf and was not a shareholder in any relevant sense in Herald, the timing issue? And it's the timing issue which is relevant in this case. And then at 1498, please, you see so this is a discussion of, it starts at 1497, a discussion of the judgments of Lord Reed and Lord Hodge for the majority in Marriott. And we see it 48 on page 1498 at the top of the page. As Lord Reed said, and we've just seen this in Marriott, the critical point is that the shareholder has not suffered a loss which is regarded by the law as being separate and distinct from the company's loss, therefore has no claim to recover it. And then we see it further down the page, Lord Reed's two types of cases. So that's set out there. And then if we go to page 1499, we see the present hearings concerned, this is paragraph 51, with identifying where the boundary lies between these two types of case. And then at 53 at the bottom of the page, it's held that the reflective loss rule does not bar Primeo from claiming in respect of the losses it suffered when it made direct investments, because those losses weren't suffered in the capacity of shareholder, it became a shareholder later. And then we see at 54 on page 1500, the losses were suffered when, as a result of breaches of duty by R1 and R2, Primeo paid money to the Ponzi fund and it was misappropriated. So the correct analysis is that Primeo suffered an immediate loss by giving the Ponzi fund money in return for the contractual right to redeem the investments. And then we see further down in the middle of the paragraph, on each such occasion it made a payment, it acquired a cause of action in respect of the loss it suffered at that time. So that loss was suffered at the time. You don't then look later when the claim is being made and say, well, what's the nature of the loss at this stage? Because going back to Lady Justice Carr's point, it is one and the same loss. So similarly, in the present case, we say that loss was suffered by each fund every time the fund entered into a less advantageous FX transaction with one of the banks as a result of their manipulation. And then at the bottom of this page, paragraph 55, it's important to note that the reflective loss rule is a rule of substantive law associated with the rule in Foss and Harbottle and concerned with the recognition in law of particular types of loss. It's not a procedural rule concerned only with the avoidance of double recovery. Applied as a substantive rule of law, whether the reflective loss rule is applicable or not, falls to be assessed as at the point in time when the claimant suffers loss arising from some relevant breach of obligation by the relevant wrongdoer, in this case, on each occasion when Primeo suffered loss on placing funds with BLMIS for investment, it did so in circumstances where the law recognises its loss as real and of a type which is recoverable. And then you see at paragraph 56 the submission that was made. So as Mr. Smith submitted, according to the analysis of the majority in Marex, the focus is on the nature of the loss, which involves consideration. So this submission is being accepted, which involves consideration of the capacity in which the claimant suffered the loss and the form of loss, i.e. whether it was suffered as a diminution in the value of shares held by the claimant or as a reduction in the dividends payable to them. The issue is one of the characterisation of the loss, which depends on its status, that is, whether it's recognised or not by the law at the time it is suffered. The test of whether the substantive rule is engaged or not in relation to a cause of action which arises as property in the hands of a person is to look at the nature of the loss at that time. And so we do place emphasis on this conclusion, because we say what that means is one looks at the loss when it was suffered by the fund, and you ask yourself, well, what type of loss is this? And in what capacity might it be said that a shareholder suffered the loss? Well, only in their capacity as shareholder, because it's consequential on the loss suffered by the company. And then we see at 59, going on to the bottom of the page, in the board's view, this reasoning provides the answer to Mr. Gillis's submission that the relevant time to assess whether the reflective loss rule is applicable is when the claimant happened to bring the claim. The submission, in effect, treats the reflective loss rule as a matter of procedure rather than as a substantive rule of law governing the nature of loss suffered by a claimant, which the law will recognise. In the board's view, since the rule is substantive rather than procedural in character, the relevant time to assess whether it applies or not is when the loss which is said by the claimant to be recoverable in law is suffered by it. The timing of the bringing of a claim and the circumstances which may pertain at that point in time are adventitious happenstance and have nothing to do with the operation of the rule. And then at the bottom of the page, paragraph 61, we see that that they relied on UCP and Nectris, and in particular Lord Justice Flo's decision in refusing permission to appeal. So in support of his submissions on timing, Mr. Gillis sought in particular to rely on Nectris. And we see the facts of Nectris there summarised. So it was an application by Nectris for permission to appeal. The origin of the dispute lay in the engagement by UCP and its 100% subsidiary Candour of Nectris to provide investment advice. Acting on that advice, UCP made a number of investments through Candour, which were in effect lost. UCP later sold its shareholding in Candour at a price which was discounted to reflect the value of the lost investments. In these proceedings, it sought damages from Nectris to reflect that discount. One of the issues which arose was whether, as Nectris contended, the claim was barred by the reflective loss rule. The judge below held it was not, and in declining to reconsider his earlier refusal to give Nectris permission to appeal, Lord Justice Flo held that the possibility that the rule was applicable to an ex-shareholder in the position of UCP was unarguable, and the applicability of the rule should be assessed when the claim is made, at a time when the lost claim has crystallised. So it was really exactly the same argument that was being put there as is being put by the banks in this case. They say, well, when the sale was made of the shares, the loss crystallised, that's some different type of loss, and so the rule in prudential doesn't apply. Then we see, in the board's view, that case is wrongly decided. Indeed, it serves to illustrate the very odd results to which Mr. Gillis's submission would lead. A shareholder which suffers a loss in the form of a diminution in value of its shareholding, which is not recoverable as a result of the application of the reflective loss rule, cannot later convert that loss into one which is recoverable simply by selling its shareholding. It's necessary to focus on the nature of the loss in respect of which the shareholder's claim is made. It's not enough to consider the position as at the date of the issue of proceedings without regard to the nature of the loss and a consideration of whether it is, in the eyes of the law, separate and distinct from that of the company. And so we say that that's a very clear formulation, and we rely on that principle, which has been very clearly set out. So you can't if you're a shareholder who suffers a factual loss because of a diminution in the value of your shareholding as a result of a wrongdoing to the company caused by a tortfeasor, you can't then sell your share and say, well, now that's converted into a loss which is new and distinct. So that simply doesn't work. And then at paragraph 62, the Privy Council there elaborate on the undesirable consequences that would arise if, on the basis of the findings by Lord Justice Flo in UCP and Nectris. And if you look at, in the middle of the paragraph at B, it leads to the conclusion, per Lord Justice Flo in Nectris, that the shareholder can sell its shareholding and then seek to vindicate its own causes of action against the wrongdoer. But this would make the reflective loss rule easy to circumvent and would subvert its intended effect, since the wrongdoer would be wary of settling with the company for fear that by selling its shares, a shareholder and prospective claimant could free itself to pursue its own claims. And we say exactly the same concern would arise in the present case. And C, it would mean, and this comes back to my lady's point, that where the company's claim comes to be statute barred, the shareholder's claim can be pursued, but such an event can't change the proper characterisation of the loss by the shareholder for the purposes of the substantive rule stated in Marex. And then we see at 63, to test the application of the reflective loss rule at the time when the proceedings are brought, rather than when the loss is suffered, would have the effect of making the wrongdoer very wary of settling with the company if the practical outcome of doing so is made uncertain and precarious by the future conduct of the company and shareholder and the vagaries of procedural law. That would undermine the intended effect of the rule, reflecting the rule in Foss and Harbottle, which is to ensure that the company has a full opportunity to decide how to pursue its own cause of action where properly identified as such, and to obtain as good value from it as possible. It would also undermine the certainty of effect which the reflective loss rule is intended to achieve as a bright line rule of law. So drawing these principles together, we say, and applying them to the present case, we say that loss was suffered each time the funds entered into an FX transaction with one of the banks, which was commercially worse for it than it would have been had the banks not infringed competition law. That under the rule in Foss and Harbottle, the only person who's entitled to seek damages for that loss is the fund. The law further treats that loss as the company's and the company's alone. The critical point being, as Lord Reid said in Marex and as the Privy Council said in Primeo, is that the shareholder has not suffered a loss which is regarded by the law as being separate and distinct from the company's loss. That's so even though the loss to the funds would have entailed a diminution in the value of the shareholdings held by the shareholders, it follows that the loss suffered by shareholders in the appellant funds in their capacity as shareholders is plainly irrecoverable. And that irrecoverable loss can't be converted into a recoverable loss by a shareholder redeeming its shares, because as the Privy Council held, the question whether the reflective loss principle applies is determined at the time that the loss is suffered.
Yes.
And so we say that the reflective loss principle therefore does apply to former shareholders, because at the time the loss was suffered, it was suffered in the shareholder's capacity as a shareholder and consisted in a reduction in the value of its shareholding in the company. So those are our submissions on company law. I'd like to look at... I'm sorry, I didn't appreciate we needed to have a break for the transcriber. I'm so sorry, because there's not a transcriber visible in the room, I hadn't appreciated that that was something we needed to do.
Very well.
So I've been...
We'll come back at 5 past.
This is convenient.
All rise.